Hello, everybody, and welcome back to Mediation Monday. I'm Alan Crone, CEO of the Crone Law Firm, and here with Jim Latta, one of our firm's affiliated mediators, to talk more about mediation, not just how we at the Crone Law Firm conduct mediations, but mediation in general. And you may be a lawyer who's looking for a mediator, or you may be a party to a lawsuit who needs to go to mediation, and our hope is that these broadcasts will fill you in on some tips and on how mediation works and help you make some decisions regarding how to proceed in mediation. And so we want to talk today about just kind of a simple concept, but it's simple, but it's not easy. And that is, how does mediation work? Or maybe a better way to say is, why does mediation work? Why can't parties, there's nothing to say parties can't resolve disputes on their own, but why does getting a mediator, a neutral third party, help? Jim, good morning. Thank you for joining us today on Mediation Monday.
My pleasure to be here. Good morning to you.
What do you think are the primary reasons why mediation works?
Well, I think there are 5 reasons primarily why mediation works, Alan. The first one is probably the most important in my experience, and that is that mediation is a safe, confidential, and controlled environment. So the participants know it's safe, that is, a mediator is in charge of the process. And at the beginning of a mediation, the ground rules are set out by the mediator as to timeline and personal needs like food and restroom facilities and things like that, but also even in terms of where people sit. The 2-room mediation is what we've been talking about. And 2-room mediation means that both parties to the mediation, if it's a 2-party mediation, have their own room, their own space, and they have their support persons with them, whether it's their attorney or not, whoever it may be. And that's a confidential room, and that is their space. And the mediator comes and meets with them in their space, then goes to the other space and communicates in that space as well. So there's a confidentiality about the mediation process itself. Now, we know legally the content of the mediation is not reported to the court. At the end of the mediation, all the court receives is the judge receives the result. Either it was a successful mediation or it was unsuccessful. It was successful, what were the results and the terms? If it was unsuccessful, that's all it said. So the parties involved feel safe in that environment. It's confidential. They're encouraged to not share what occurs in the mediation itself. And, it's up to them if they talk about it, but really it's in their best interest if they generally don't. So it's very confidential and it's controlled. Many of these parties to a mediation have had experience of conflicting with the other party to the mediation in an uncontrolled context, a family argument or just an argument generally, or within a, partnership breakup, or whatever the context that's needed the mediation. So to have it controlled by the mediator, I think brings a measure of relief and clarity of mind. The fact that the mediator can caucus at any time with the parties, which is a caucus in mediation world is a direct mediator to party, one of the other parties, private conversation, and the parties can request a private conversation with the mediator as well. The fact that there's that kind of respect and that communication and permission to be communicative about these matters, I think is of utmost importance. As a counselor and a therapist, as you know, counseling is confidential, and I find that makes people much freer to open up and to truly trust the process.
Well, when a mediator is involved, does the mediator have a specific role in controlling the communication between the parties?
Absolutely. As we mentioned, initially ground rules are sent out, as we've said in the other Mediation Monday moments we've had. Mediator sets the ground rules and guarantees that everyone will be heard, number one. Number two is the most important role, I think, from a communication standpoint for the mediator is that the mediator filters and limits unproductive interactions between the parties. By filtering is not the same as editing. Mediator doesn't edit what the parties say to the conflict, but the mediator can limit unproductive, energy using, anger producing, resentment creating conflicts in what is said. I've noted over the years that what occurs in a conflicted communication many times is what I like to term fragmentation. That is, party A to the mediation is conflicted with party B. And if they are basically put in a room together to argue, what happens in my experience, Alan, is that the communication fragments into unresolved issues of all kinds. It tends to creep from the primary reason of the conflict in the beginning. And so that fragmentation works against the old adage, keep the main thing the main thing. That is, in the mediation, the main thing is the conflict that caused the mediation to be. That's what we're there to work through. The goal is to resolve that conflict. Fragmentation into other areas of conflict between the parties does no good, no purpose, does not move the mediation toward the goal. And the mediator can play a pivotal role in keeping the focus on that, keeping the main thing by suggesting and reflecting back to the parties what's occurring in their communication as they communicate through the mediator to each other. And the mediator can use things such as, I hear you say, and what I'm understanding is, clarify this for me, these types of things to help the parties communicate more effectively and efficiently.
I think another reason why mediation works is that a mediator brings certain specific skills to a mediation that as a neutral, he or she can bring that the parties or the parties counsel, who also may be trained as mediators, can't bring because of their bias. I always say there are two kinds of mediators. There are mediators who conduct mediations, and then there are mediators who settle cases. And I think the latter are the ones that can bring those specific skills and inject them at the right time to help overcome impasse, because parties can talk to one another back and forth informally and may not get anywhere. Sometimes it's those skills that helps break open the impasse.
Absolutely.
What are the kind of skills you think a good mediator brings to help resolve impasse?
I think one of the biggest skills a mediator can bring to that, Alan, is in the communication realm, and what I like to term listening between the lines. When people communicate, you know very well in your work as well that people communicate at multiple levels at the same time. And what is communicated may have subterranean meanings to it and subterranean connections and emotions and thoughts that are not overtly spoken. So listening between the lines is my terminology for what is important for a mediator to facilitate the parties to the mediation to listen to what the other side is communicating. And that does require a lot of energy and a lot of attention. And again, it requires a cohesive attention to the process, which fragmentation does not help at all, okay? It works against that. And in my experience, fragmentation promotes impasse, which is not what we're after at all. That is the blocker to a good mediation outcome. There's a really wonderful resource out there that I would encourage um, listeners, watchers of what we're doing right now, and those participating in mediation. In fact, those who participate in communicating through conflicted situations at all, and we all have those in different realms. And that's called Difficult Conversations, which is a seminal work, a seminal book, paperback. The subtitle is The Harvard Negotiation Project. And it's just fascinating to read it because in the mid-90s, late 90s, at Harvard was brought together just a multidisciplinary group of people, about 25 people, all kinds of different disciplines, attorneys and mediators and counselors and communications theorists, and came to Harvard, and they talked about how can we possibly pool our knowledge to help human beings resolve conflicts more effectively. And the book is a result of that. But in the book is clearly put some important things for people to realize, whether it's in a marriage or at work or anywhere else, how to resolve conflicts. And one of the major focus of that book is that you listen between the lines. That's my language, but that's what they're trying to communicate. You hear what's said and what is unsaid. So I think that's one thing that a mediation skill to have, that a mediator can really promote and can share and can model for the people involved.
Well, very good. You know, I think along those lines, that none of those things can happen unless all of the decision makers are present. And that's I think another often overlooked focus of mediation, or element of mediation, is the fact that you have all the decision makers present. They can focus in on the situation, and it's almost like an appointment to settle the case. You know, everybody gathers, and if you walk away without a settlement, there's kind of a sense of failure if you don't settle the case. Sure. And that can be a very powerful motivator to achieve resolution.
Sure. And they're all present. The decision makers should all be present. That's one prerequisite to a mediation, is that all the decision makers need to be there to be participatory, and also to contribute, and also to feel invested in the process. But beyond that, it also allows the mediation to move forward with its own momentum, which has been built. And that requires continuity, Alan. It requires a continuity of process, a continuity of communication and participation. So it's important to have all those decision makers present and engaged. And that is the mediator's job, is to keep people engaged in the process. It is a voluntary process, as you know, but it's really important to keep people contributing, listening, actively participating and contributing. Because it is up to the parties with mediator facilitation to resolve the conflict. As you know, there's no judge present to just make a decision, a bench decision. But it's up to them. So it's a direct result of their effort, availability, their focus, their attention to what is being said, and also, as I've indicated a little bit, between the lines, attention to what is not being said. And I think that I think that is really important. I've been involved in a mediation of a family that has been in a bitter struggle over an aged implement of farm management. It's a bunch of junk. It's just really junk in a field. But that bitter fight has been over, not about that old farm implement. It's about unresolved issues within the family. And you know very well from your experience too, that those things can erupt around any ignition point. So it's critical that we listen to what is being said and what is not being said, or not being said clearly. And that way keep the focus on the main thing as the main thing and the reason for the mediation, and keep the momentum up so the participants can stand back and look at the big picture and not get derailed, distracted, and embroiled in unresolved side issues to sap off energy and attention and possibly create an impasse. That's what we don't want.
You know, you mentioned big picture, and I think that's so important, because I frequently, and it depends on the dispute, obviously, but very frequently I see in mediation people realizing kind of mid-mediation how this dispute fits into the big picture of their life, and all of a sudden maybe it becomes, I don't want to say less important, but they realize that they've got many other things to deal with, and getting this matter resolved will improve their big picture, even if they don't get exactly what they want.
Totally agree. And I've noticed as well that in doing that very thing, Alan, standing back, almost giving yourself a timeout a little bit, an adult timeout, to reflect on what are my goals here, it's very de-stressing for the parties involved. We've talked about having safety, having continuity, having a facilitated mediator doing a good job bringing out communication, keeping the main thing, not getting off on side battles and wars unresolved from the past. But also in doing that, in standing back and reflecting on what is the big picture and thinking about the impact of the mediated outcome on not just themselves, but everybody else that they love and care for, work with, have a relationship with. To be able to do that really is de-stressing. It can help us, strangely enough. Now, it's a lot of work. I'm not saying it's not fatiguing, but it does reduce anxiety within the parties involved so they can be freer to move ahead and even think new thoughts. Think outside the box, as the phrase goes, okay? And think about new ways to solve issues and what they're open to, and therefore be more flexible. So mediation goes on, the momentum goes on, and then you, most of the time, end up with a good outcome.
I agree. And what people get a lot of times with mediation is certainty. They no longer have the dispute hanging over their head, even if they didn't quite get the deal they thought they wanted going in. I know very few people who wake up the day after the mediation saying, you know, I miss that dispute. I miss being embroiled in that controversy.
That's right.
You know,
that's right.
And you say they move on. And that is the beauty of mediation.
And I'll be willing to bet you few of them wake up and say, I wish I wasn't as anxious as I was the day before the mediation.
Right.
I don't think they're going to embrace that either.
Well, very good. Thank you, Jim. That is all the time we have for this week's Mediation Monday. Hopefully, our viewers and listeners have enjoyed this and gotten a little bit of benefit out of it. Look for us next Monday when Jim and I will talk about co-mediation and impasse. Again, Jim, thank you so much, and we'll see you all next week on Mediation Monday from the Crone Law Firm.